Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where the heck are we today? We are on the beautiful campus of Washington State University, my alma mater. Hey, America, after starting the week with some really terrible news out of the United States Supreme Court, we got really good news out of the United States Supreme Court. But I got to be honest with you, it really wasn't unexpected. I always expected that we would win this case. We're talking about the case, obviously, of Smith & Wesson v. Mexico. I had predicted that we were going to win it 8-1. Turns out we've actually won it 9-0. But there's a little nugget in this opinion that I think some of you may have missed, but I need you to pay attention to it. So today, let's spend a few minutes and let's talk about, does today's Supreme Court ruling open the doors to challenge assault weapon bans? Okay, America, we're coming to you again from the campus of Washington State University here in beautiful Pullman, Washington. Need to talk to you about the case of Smith & Wesson versus Mexico. We just had a ruling come out from the United States Supreme Court this morning. As you know, the decision is 9-0 in favor of Smith & Wesson. Now, let's go back in our time machine just so you could understand what this lawsuit was about. What it basically was about was the Mexican government was suing Smith & Wesson and many other firearms manufacturers that were eventually kicked out of the suit for creating Mexico's gun violence problem. That's right. Essentially, they wanted to sue American firearm manufacturers because they were unwilling or incapable of doing things about their drug cartel violence problem. Now, you also may recall that there is a federal statute directly on point called the Protection of Lawful Commerce in Arms Act, which said these types of lawsuits are not even legally possible. For whatever reason, the First Circuit didn't get that and it actually had allowed the lawsuit to move forward under a theory that, well, Smith & Wesson and other gun manufacturers were aiding and abetting. The court's ruling as it related to the issue to be decided today is as follows. Here, the government of Mexico sued 7 American gun manufacturers, alleging that the companies aided and abetted unlawful gun sales that routed firearms to the Mexican drug cartels. Despite the fact that they had absolutely zero evidence to suggest that these firearm manufacturers are selling directly to the cartels, because they weren't, the court went on to further state, the basic theory of its suit is that defendants failed to exercise reasonable care to prevent trafficking of their guns into Mexico, and so are responsible for the harms arising there from the weapons misuse. Yeah, even though there is like 8 degrees of separation with a ton of illegal activity, none of which Smith & Wesson was involved in, to get the firearms there, no, the Mexican government figured, no, we should just blame Smith & Wesson. It alleges that the manufacturers were willful accessories in the unlawful gun sales by retail gun dealers, which in turn enabled Mexican criminals to acquire guns. And it sets out 3 kinds of allegations related to how the manufacturers aided and abetted retailers' unlawful sales. So the crazy theory under which the Mexican government believed that Smith & Wesson, and oh, by the way, the First Circuit would have believed this as well, was liable was, the manufacturers allegedly 1, supply firearms to retail dealers whom they know illegally sell to Mexican gun traffickers. 2, have failed to impose the kind of controls on their distribution networks that would prevent illegal sales to Mexican traffickers. And 3, make design and marketing decisions intended to stimulate cartel members' demand for their products. That's right. That's the theory under which Mexico believed that they could establish liability on behalf of Smith & Wesson and several other firearms manufacturers. The court has held, because Mexico's complaint does not plausibly allege that the defendant gun manufacturers aided and abetted gun dealers' unlawful sales of firearms to Mexican traffickers, the PLCAA bars the lawsuit. Okay, now the opinion is authored by Justice Kagan. There is concurring opinions from Justice Thomas and Justice Ketanji Brown Jackson. However, and I want you to remember that Justice Sotomayor made a statement quite similar to this. At the bottom of page 13, top of page 14, Justice Kagan refers to semi-automatic rifles as follows. Finally, Mexico's allegations about the manufacturer's design and marketing decisions add nothing of consequence. As noted above, Mexico here focuses on the manufacturer's production of military-style assault weapons, among which it includes AR-15 rifles, AK-47 rifles, and .50 caliber sniper rifles. But those products are both widely legal and bought by many ordinary consumers. The manufacturers cannot be charged with assisting in criminal acts just because Mexican cartel members like those guns too. Okay, did you just see what Justice Kagan admitted to? Justice Kagan just admitted that these firearms are in common use for what? Lawful purposes. And despite the fact that this court has decided that they are not interested in the assault weapon ban case as it relates to Snope, we now have Justice Kagan, and again, let's remember that Justice Sotomayor made a similar statement where now 2 of the liberal justices have admitted that this is the most common form of long gun available and in circulation in the United States right now. So when and if we could actually get a assault weapon ban challenge in front of the United States Supreme Court, it will be very interesting to see how these 2 justices back their way out of their previous statements. So at the end of the day, this is a big win, but it's a win that was well-deserved. And the fact that it's a 9-0 decision demonstrates exactly how well-deserved this win was. But perhaps, like many other cases, the true beauty, the true value will lie in language unrelated to the actual ruling itself, like the admission from a liberal justice who authored this opinion that in fact the AR-15 is in common use for lawful purposes. Okay, America, the case once again is Smith & Wesson versus Mexico. We're going to link it up down below so that you can geek out on the ruling for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video we should be doing, we want to hear about it by you clicking on that link right there and telling us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From the fantastic campus at Washington State University, thanks for watching and stay safe.